Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to discuss whether or not you have to identify yourself to a police officer. Cop walks up, asks you who you are. Do you have to identify yourself? As you might imagine, a lot of people think this runs afoul of the Fourth Amendment or the Fifth Amendments in the Bill of Rights. And you'll often see people arguing this at the side of the road, telling a police officer, I don't have to answer that question because it violates my rights. And they'll often say the Fifth Amendment if they feel like giving out a enumerated right as a support to that good position. But here's the thing. It depends what state you're in and the circumstances you're under. But, I can tell you right now, all 50 states require a driver who's driving an automobile on the public roads to show a driver's license to the police officer who asks for one. In fact, and that's not even identification. That's more specific, as in you have to have a valid driver's license to display. But the question then becomes, what about a passenger in a vehicle? Or what about you're just walking down the street one day, minding your own business, and a police officer walks up to you and says, identify yourself, sir or ma'am. Do you have to do that? And I hate to say this kind of an answer, but it depends on what state you're in. Because there are 24 states that have got what they call stop and identification laws, stop and ID laws. Michigan does not have them. So I am not required to necessarily cooperate with the police officer who asks him for ID, depending on the circumstances. But if you're in Nevada, you have to. And the reason we know this is there's a Supreme Court case called Heibel versus 6th Judicial District Court of Nevada. Case came down in 2004. And it's a great story because the Sheriff's Department in Humboldt County, Nevada received an afternoon telephone call. That's important. Reporting an assault. The caller reported seeing a man assault a woman in a red and silver GMC truck on Grass Valley Road. A deputy was dispatched to investigate, and when he got there, he found a truck, matching the description that he was told about, parked on the side of the road, a man standing by the truck, and a young woman inside the truck. And the officer observed skid marks in the gravel behind the vehicle, leading him to believe that it had come to a sudden stop. So something's going on here at the side of the road. The officer approached the man and explained he was investigating a report of a fight. The man appeared to be intoxicated. Nothing better than being intoxicated in the middle of the afternoon at the side of the road talking to a cop. Your day gets just can't get any better than this. The officer asked him if he had any identification on him, and the man refused and asked why the officer wanted to see his ID. The officer responded that he was conducting an investigation and needed to see some ID. The unidentified man became agitated and insisted he had done nothing wrong. The officer explained that he wanted to find out who the man was and what he was doing there. After continued refusals to comply with the officer's request for identification, the man began to taunt the officer, challenging him to arrest the man. The routine kept up for several minutes, with the officer asking for identification 11 times and was refused each time. After warning the man he would be arrested, he was arrested. So the man at the side of the road making an ass of himself was Larry Dudley Heibel, and he's charged with willfully resisting, delaying, or obstructing a public officer in discharge or attempting to discharge a legal duty of his office in violation of a Nevada revised statute, and it's one of these stop and ID laws. And here's the thing, about 24 states, give or take, have stop and ID laws. So if you need to know whether your state's got one, simply type in stop and ID law, and you'll find several websites that have lists of all of them, including Wikipedia. And then some of the sites will actually tell you what the specifics are in your state. But the stop and ID law in Nevada says that any peace officer may detain any person whom the officer encounters under circumstances which reasonably indicate that the person is committing, or is about to commit a crime. And the officer may detain the person pursuant to the section only to ascertain his identity and the suspicious circumstances surrounding his presence abroad. Any person so detained shall identify himself, but may not be compelled to answer any other inquiries. So this is a very, very narrow statute. The statute simply says a police officer with a reason to investigate may ask you to identify yourself, but can't ask you anything further. But it also says that you're required to answer the question. You have to identify yourself. So when he failed to do it, he was found guilty in the Justice Court of Union Township, and he was fined $250, and he took it up on appeal and wound up in front of the U.S. Supreme Court, and that's why I'm talking about him now. So the Supreme Court, in their opinion on this case, lists the states that have got the stop and identify statutes as of that moment in time. That may have changed since then. But the Supreme Court points out that these kind of laws go way back. They go back to, common law, back at a time when English vagrancy laws required suspected vagrants to face arrest unless they could give a good account of themselves. I like the way they phrase that. And the court has recognized that there are limitations on the scope and operation of a stop and identify statute, but the question simply is it narrowly tailored to simply help the police identify somebody during an investigation? And so they said as of the time of this case, they had not addressed this specific issue yet. And so there's no question that the initial stop was based on reasonable suspicion, and that satisfies the Fourth Amendment requirements noted in the previous cases. The petitioner argued about the constitutionality of the law. Supreme Court said, that the law is actually written pretty well. It's tailored very well to this. He also says that it doesn't make sense to allow people the police to ask people questions. Asking questions is an essential part of police investigations. So says the Supreme Court. And their previous decisions make clear that questions concerning a suspect's identity are a routine and accepted part of a Terry stop. And a Terry stop, I've talked about before, the police officer have reasonable suspicion to detain you and simply just stop you and question you. That's called a Terry stop. You're not under arrest. You're being detained. And in a situation like that, if the police officer has suspicion to think you might be armed and dangerous, can also even perform a pat down on you to look for weapons. Okay, I'm not talking about Terry stops today. I'm simply talking about, do you have to identify yourself? The simple act of identifying yourself. So the Supreme Court said that the stop and ID laws do not violate the Constitution, at least not the Fourth Amendment. But when it comes to the Fifth Amendment, are you being compelled to testify against yourself and giving your name? And that's one of the most comical parts of any video you watch on YouTube, where someone gets pulled over by the police, and the police go, I want to see your driver's license. And they go, I'm not going to give it to you. They go, why not? I say, because of the Fifth Amendment. Giving the driver's license to the police is not testimony against yourself. How is it? How are they going to use it against you? In fact, the driver's license is what we call exculpatory. It's going to help you get out of trouble, not put you in trouble. Unless you hand them a fake driver's license, which is not what they're asking for. Or if you hand them an expired driver's license, which, again, I don't think they're asking for that. But so petitioner contended that his conviction violated the Fifth Amendment's prohibition on compelled self-incrimination. And they point out that the Fifth Amendment prohibits only compelled testimony that is incriminating. So as we stated previously, the Fifth Amendment privilege against compulsory self-incrimination protects against any disclosures that the witness reasonably believes could be used in a criminal prosecution or could lead to other evidence that might so be used. Suspects who have been granted immunity from prosecution may therefore, for instance, be compelled to answer with the threat of prosecution removed. There can be no reasonable belief the evidence will be used against them. In this case, petitioner's refusal to disclose his name was not based on any articulated real and appreciable fear that his name would be used to incriminate him, or that would furnish a link in the chain of evidence needed to prosecute him. As best we can tell, petitioner refused to identify himself only because he thought his name was none of the officer's business. Even today, petitioner does not explain how the disclosure of his name could have been used against him in a criminal case. And I challenge anybody, how is your name going to be used against you? I mean, they're going to call the case, the state of Michigan versus Bob Johnson, but your name's not being used against you. It's just being used as the title of the case. Silly. So it says, while we recognize petitioner's strong belief that he should not have to disclose his identity, the Fifth Amendment does not override the Nevada legislature's judgment to the contrary, absent a reasonable belief that the disclosure would tend to incriminate him. So here's the thing. You're walking down the street, any state, USA. Police officer walks up to you and says, who are you? What's your name? Identify yourself. Here's the thing. In the 24 states that have got stop and ID laws, you're going to want to double check to make sure exactly what you need to do in your state. But for instance, in Nevada, if the police officer has reasonable suspicion and he's investigating something based on that reasonable suspicion, if that officer asks you for your identification and you don't give it, you can be arrested for that alone. Now, you might say, Steve, he needs to have reasonable suspicion, right? Yes. So you ask the officer, do you have reasonable suspicion? As we've discussed previously, he doesn't have to tell you. There's no law that says he's got to tell you. It just says he's got to have it. So if you want to run the risk of being arrested for refusing to identify yourself in a state that has a stop and ID law, you can do that and hope that you can defend it later by saying he had no reasonable suspicion. But all that would take, for instance, is let's suppose somebody calls the police and goes, hey, there's somebody breaking into cars over here. Police car zooms over there, and 30 seconds later, cop jumps out and just sees you walking down the street. You're the only person in the vicinity. You're the only person there. Is that reasonable suspicion for him to ask you who you are? It probably is, because a crime was committed right near where you are, right around the time you were there. That's reasonable suspicion. You could be the guy breaking into cars. So when the police officer asks you that and you weren't breaking into cars, you never heard any cars being broken into, you don't know about the car breaking into's, okay? The point is, you don't know whether or not the police officer has a reason to be asking you this. But a bigger question is, why won't you tell him? And I understand people out there right now going, Steve, this is the first step on the slippery slope in the long march towards Nazism, fascism, communism, anarchism, atheism, Hinduism. I mean, it's some ism that we're going to, and the second you let a cop ask you what your name is, next thing you know, they're kicking down the door and killing your puppies. Okay, I don't buy all slippery slope arguments. You know, we've had speed limits for years, and they still let us drive. But a police officer asking you your name, I understand there might be a cop out there harassing people and asking you for identification. There might be. I like to think that most cops out there are good. The bad ones, the ones that give them a bad name. But the cop who walks up to you and says, excuse me, you know, who are you? You can ask, why are you asking? The police officer might just say, just asking. And you can ask, do I have to tell you? That might be a good thing to ask. But if the police officer says, yes, you do, and you're in a state that's stop an ID, you should probably answer the question, because if he says you got to tell him, and there's a law that says you got to tell him under certain circumstances, all he's got to do is come up with certain circumstances to get you arrested and make it stick. Now, here's the thing. If you are in a state that does not have a stop an ID law, Michigan has no such law, okay? You're walking down the street, cop walks up to you and goes, excuse me, can I see some identification? And you say, I'm curious, why are you asking me? And he says, I don't have to tell you that. You say, am I free to go? And if he says, yeah, you're free to go, go. Run like the wind. But if he says, no, you're not free to go, at that point you get into a really interesting situation, because you say, why am I not free to go? Now remember, if the police officer is going to arrest you, and he has probable cause to arrest you, or reasonable suspicion to detain you, does not have to explain to you what those reasons are at that time. He must have them, but he doesn't have to explain them to you at that time. You can get into this weird situation where you can go, okay, I'm not going to identify myself until you give me a reason why I've got to. Because there's no stop an ID law in Michigan that I'm aware of, unless something's changed very, very quickly recently. And the police officer can just say, okay, you know, and then you wind up in this weird standoff. I suspect that most police officers, if they actually had no reasonable suspicion and had no probable cause, would probably then eventually let you go, okay? But again, what I'm talking about here is you being stopped at the side of the road, just walking down the street, not in a car, but just walking along, just minding your own business, out and about in the public, okay? Police officer asks you for identification. If you're in a stop and ID state, the standard's higher and you might be more required to do it. In a non-stop and ID state, no requirement that you do it. You're not going to go to jail simply for that refusal, okay? The question is whether you're going to tick them off enough to make them find something else to get you for. But by the way, just in case you're curious, and this is something most attorneys know, just you can ask them, they'll tell you this, is that if you get arrested, you're actually arrested, handcuffs, back of the cruiser, taken to the police station, brought in, perp walk, everything, and they're fingerprinting you and mug-shotting you, and they ask you, what's your name, okay? You cannot say, I'm taking my Fifth Amendment right against self-incrimination there. Because courts have ruled and said that's not a violation of your Fifth Amendment rights to ask you what your name is. Now, obviously, they can't force you to speak. I've talked before about how you want to. You can just climb up and just not talk. But the point is that let's suppose you haven't been Mirandized yet, okay? And they bring you to the police station and they go, what's your name? And you go, my name's Steve Lehto. And then later on, oh my gosh, I wasn't Mirandized, and they started questioning me. They were questioning me. What was the question? What's your name? Okay, that's not questioning. That's not interrogation. And that's the difference. So to ask you what your name is never going to violate your Fifth Amendment rights. And I challenge you to find an example where that would be the case, because I can't imagine one. And like I said, the Supreme Court's already ruled. The case I cited just a moment ago about if you've already been arrested, it is not an interrogation to be asked what your name is. That's Pennsylvania versus Muniz, a case from 1990. Case came down while I was in law school. And the case about the guy at the side of the road who was agitated, intoxicated, and eventually arresticated, that was Heibel versus 6th Judicial District Court of Nevada. That case came down in 2004 and is still considered to be good case law. So again, if you're driving, you have to display the driver's license. If you're just out and about walking and minding your own business, if you're in a stop and ID state, the police might have a legal reason to demand you identify yourself. And if you don't, you could be arrested under a stop and ID law, which has been specifically upheld as constitutional. If you're in a non-stop and ID state, then you may not have to identify yourself, but then you get in that weird game of chicken at the side of the road. So again, sorry for repeating myself, but I want to make this very, very clear, because I guarantee you that within 3 comments, someone's going to get it wrong or have missed everything I just said. So as always, questions or comments, put them below. Otherwise, talk to you later. Bye.